I just sent you my email in chat.
I did. I received it. I'm about to write it down and then I'll just send.
Okay, here we go. All right. Johnson. Good morning, Mr. Bradford.
Good morning.
Who are you on?
I have Robert Sewell this morning.
All right.
Thank you.
All right, Attorney Nelson, who are you on?
I'm here on Mr. Johnson, but it appears he's retained out. I see he's appearing from Attorney Daniel Reed's office.
Yeah, I haven't got an appearance. I'm waiting on it, but yeah, he is here.
Mr. Johnson, could you just confirm that you've hired an attorney and you don't want Neighborhood Defender Services help anymore?
Mr. Johnson's not on.
We'll be waiving his appearance, and he did retain us, and the appearance is on his way.
Okay, all right, thank you.
All right, I think I got everybody.
36th District Court, City of Detroit, State of Michigan, now in session with the Honorable Judge Ronald Johnson presiding.
Right, okay. I seen it, James.
Yeah, it's early in the morning, sorry.
That's okay. I got it. Parties ready on Harvey Johnson,
Yes, Your Honor.
calling case number 2358722, the people of the state of Michigan versus Harvey Johnson. Defendant is charged with count 1, controlled substance, delivering, manufacturing cocaine, heroin, or another narcotic less than 50 grams. Count 2, weapons, felony, firearm, habitual offender, third notice. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Agent Lewis for the people, P 85520.
Oh, I got it late yesterday.
Good morning, Your Honor. May it please the court, Daniel Reed, P number 30965, appearing on behalf of Mr. Johnson. We do present this matter proceeding by Zoom, and we ask the court permission to waive our client.
Waive his appearance for the purpose of this proceeding.
Thank you, Your Honor. We'd like to sit the matter for you down.
Are you available September 19th at 11 o'clock?
Yes, Your Honor. Oh, no, we're in trial that day. I'm sorry, Your Honor.
How long is your trial?
I don't know. It shouldn't last more than 2 or 3 days. So is the 21st available? Or the 21st or 22nd?
21st at 10:15?
That's perfect, Your Honor.
Okay.
Appreciate you.
Anything else?
Nothing further, Your Honor. We thank the prosecution and the court. Everybody stay safe.
He doesn't have this information.
Calling case number 2358761, the people of the state of Michigan versus Devontae Ponset. Defendant is charged with count 1, police officer assaulting, resisting, obstructing, habitual offender, second notice. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Agent Lewis for the people, P 85520.
Morning, Richard Banta, P 39845 for Devontae Poinsett. Granted, today's date's up for PCC. I haven't had a chance to go over the discovery material, but I anticipate holding the preliminary exam in this matter.
Firearm, or are you waiving his appearance for purpose of today's hearing?
Yes, sir.
He's on, Judge.
He's on.
Yeah, he's on Zoom.
Mr. Ponzek, can you turn your video on, state your name for the record?
My name is Devontae Poinsett.
Thank you.
I'm starting court right now.
I beg your pardon?
I'm starting court right now because I'm on my way to
Yeah.
my lawyer office and I'm like 2 minutes away.
Do you have a retained attorney? Mr. Poinsett, do you have a retained attorney?
I got my own attorney. I'm pulling up to the office right now.
Probably have to just go ahead and set.
Yeah, I'm pulling in right now. I didn't know the court was gonna start this so soon.
Well, it's set for 8:30. I start my cases on time, sir.
Well, I just got to the office, sir. Got to ring the doorbell.
All right, I'm gonna recall this case in a couple minutes.
There's no appearance.
The council, I need to make sure that.
Nice to see you. I haven't seen you for a while.
Beg your pardon?
So it's nice to see you. I haven't seen you for a while.
Yeah. You too. My kid is doing something else. Mr. Poinsett, put your system on mute. Hey. Poinsett, yeah, thank you.
Okay.
Put your system on mute.
Oh, my attorney's in the waiting room.
Put your, all right.
What's your attorney's name?
Odie, hold on, I gotta ask him how to pronounce his last name.
Is it
Odie, how you
M-E-R?
pronounce your last name? How you pronounce your last name? Odie Miraway.
He's on, I just let him in. He didn't have to turn his name.
Again, this is recalling 2358761. People of the state of Michigan versus Devontae Poinsett.
Oh, excuse me.
Agent Lewis for the people, P 85520.
Morning, Your Honor. O'Day Mayorway for Mr. Poinsett, who's appearing by Zoom. Your Honor, I did file my appearance on 2 days ago. I sent it by fax and then I mailed it in. It must not have been processed yet.
I need another appearance. I need to send it directly to my clerk because I don't have it.
Fair enough, Judge. I can email that in just a moment. I will look up your, or if you can chat me the the email address to send it to, I'd appreciate it very much.
I'm sending it now, Counselor.
Counselor, let's put your name on the record and I'll excuse you.
It's O'Day Mayorway, P764.
I'm talking, he had a appointed counsel. I'm allowing him to put his name on the record and then he's gonna be excused off the case.
Fair enough, Judge.
Good morning, Your Honor. Richard Bant, P 39845, assigned counsel for Mr. Poinsett, I think his name is.
All right. Well, he now has retained counsel for the court will excuse you.
Thank you.
Thank you. All right. Mr. Poinsett?
Yes, sir.
Just so you know, in the future, I don't do t-shirts and I don't do sweats in my courtroom, even on Zoom. So please.
Okay.
All right.
I can take it off.
No, you're right, just in the future, so you know. Okay? All right, thank you. All right, counsel, we're setting this matter for exam.
Your Honor, can I get another PCC date while I try to get discovery here and determine if we're going to set it for exam or not, Judge?
If you can give me your P number, we have this number for you.
Oh, great. It's 76460.
Okay, they'll send you the discovery today. I don't adjourn the PCCs.
That's fine, Judge. If I'm going to get it today, that's not going to be a problem. I appreciate it. And we'll set it for the exam, and if we're going to waive, I'll let the court know prior.
Okay. So you're available December 19th at 11 o'clock?
September.
I said December or September? No, September 19th.
December 19th would have been a no, but September 19th, at what time, Judge?
September 19th at 11 o'clock.
11 would be great. Can we do 11:30 by any chance? Would that be too late? I'm the city attorney in Hamtramck. We have a docket that morning. I just want to be safe.
Yeah, I'll do 11:30.
Thank you, Your Honor. Thank you, Your Honor.
Okay, anything else?
No, Judge.
Counsel, was there anything else?
No, thank you, Judge.
Okay, thank you. All right, that concludes the hearing. Bob, continue.
Okay, Judge. So I'll let you know when I get what they got.
So court's over.
Court's over.
Yeah.
When was that back to court?
Sign off.
Next Tuesday.
Next.
We're gonna be in person.
So we gotta go down there.
Yeah, that'll be in person.
36 days. Next to.
Mr. Bradford,
Yes, ma'am.
are you ready?
Yes, ma'am.
Okay, your client is not on. I have people in the waiting room, but they're not naming their device. So I can't let them in.
Yes, ma'am. If we could waive his appearance, I'm ready.
All right. Calling case number 2358755, the people of the state of Michigan versus Robert Swell. Defendant is charged with count 1, police officer assaulting, resisting, obstructing. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Asia Lewis for the people, P 85520.
Good morning, Judge, to you and your staff. Cody Bradford with Neighborhood Defender Service, P 85944. I would request to waive Mr. Sewell's presence for the purpose of today's hearing.
All right, we'll waive his appearance for the purpose of today's hearing.
Yes, Judge. Other than that, I would like to set this for a preliminary exam. If you remember from yesterday, Judge, I do have 2 trials next week. So if we could, if you have availability on the 25th or 26th, I would appreciate it. That's within the 2 weeks.
September 25th at 10:30.
Yes, Judge, I'm already in front of you at 10, so that works. Other than that, nothing else from defense.
Okay, thank you. That concludes the hearing.
Thank you. Have a good one.
You too.
Jeff, did you want to wait on your client, or you ready?
I'll waive him.
Okay.
Yeah, I'll be right over.
Calling case number 2358125, the people of the state of Michigan versus Nathaniel Cotton. Defendant is charged with count 1, weapons carrying concealed, count 2, assault with a dangerous weapon, felonious assault, count 3, weapons felony firearm. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Asia Lewis for the people, P-85520.
And good morning, Your Honor. James Schloff, 30720, on behalf of Mr. Cotton.
All right, waive his appearance for purposes of this hearing.
I do. I suspect he's in the waiting room.
All right. Send this matter for exam.
Yes, please.
Are you available September 19th at 11 o'clock?
Actually, Judge, even though it's my birthday, I'm working hard that day. I got plenty of stuff. Could we do it the 21st, please?
Do September 21st at 10:30.
That'll be fine. Thank you. I believe I do have the discovery. If not, I'll contact the prosecutor if I need anything.
Okay.
Yes, discovery was sent to you.
Thank you.
All right, and that concludes the hearing. Thank you.
Sure.
Parties ready on Gabriel Larry?
I'm ready.
Calling case number 2358747, the people of the state of Michigan versus Gabriel Larry. Defendant is charged with count 1, police officer fleeing third-degree vehicle code. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Asia Lewis for the people, P-85520.
Good morning, Your Honor. Alicia Martin, P69003, on behalf of Mr. Larry. Mr. Larry is present on Zoom.
Larry, can you state your name for the record, please?
Good morning, Your Honor. Gabriel Larry.
Thank you, sir.
Your Honor, I'm looking for an exam date.
Okay. Are you available September 19th at 11 o'clock?
Checking my calendar, Judge. No, I'm not available at 11. I'm available on the 20th in the morning. Anytime after 10:30.
All right, 20th at 10:45.
That'll work, Judge. Thank you.
Okay.
Judge, can you put me in a breakout room with Mr. Larry?
Sure.
Thank you.
So that's September 20th in person at 10:45, and we'll put you in a breakout room. So Larry, need you to accept the invitation? 1 second. Okay.
Yeah.
Good morning, Judge. We're ready on Black. He said he was in the waiting room.
Well, if he hasn't,
No, I let him in. There he is. He's in.
all right.
Calling case number 2358219. The people of the state of Michigan versus Aaron Black. Defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. Count 2, count 3, count 4, count 5, personal identifying information obtained, possesses, transferred with intent to commit identity theft. Matter is scheduled for a probable cause conference.
Good morning, Your Honor. Agent Lewis for the people, P-85520.
And good morning, Your Honor. Robin McCoy on behalf of Mr. Aaron Black. I did talk to Mr. Black. He wants to hold the preliminary exam. I'm out of town from the 20th to the 24th of September, so we would want to see if the court has a time before that or after.
All right, Mr. Black, can you state your name for the record, please?
Aaron Lionel Black, Your Honor.
Thank you, sir.
Yes, sir.
All right, counsel available September 19th at 11 o'clock?
Yes, I could do that. So it'll be September, just so it's clear for me and the client, it's September 19th. It's in person, live exam, correct?
That's correct.
Okay.
September 19th in person.
That's room 233, Mr. Black. So, okay, thank you, Your Honor. I hope you and your staff have a good day.
All right, thank you, you too. Take care.
Thank you, Your Honor.
Thank you.
That's all I have right now on PCCs.
Hmm?
That's all I have right now. Mhm.
Yeah, first case. Right, what's the other two? First two. Right, that's right. All, just the two at the end. So, first defendant on the second page, he's nine.
Oh.
Bonds are low, so I think that's why. That's what you get.
No, 27. That starts. Oh, yeah. I'm in Mexico from through January 6th.
That's God's. You're really ready.
Yeah.
Yeah. I know you are.
I know. Well, I gotta go to, Chicago. Square. That's not. But they on the other time. They go up north. I take you down place. Take your brother. I thought, because I remember you said he's so good, it's the day usual. Yeah. Be here before you know it, Jimmy. Before you know it. Take us up on these over. Right. I'm a
Good morning, Mr. Townsend.
Morning.
Okay, we're just waiting on your attorney right now, okay?
All right.
All right, if you can just put your device on mute until we call your case.
Okay.
Thank you. Good morning, Mr. Ferguson.
How you doing, man?
Good. So we're just waiting on your attorney right now. If you can just please put your device on mute.
Okay, man.
All right. Thank you.
I have no idea. There you go. Yeah, you see, keep it around. He took. That's why he was.
This is Kitty. He's at ECC for today.
And then Montez Townsend.
Certainly have
Yes, it's scheduled for today. It's scheduled for today. Original service, 965-2282. Yes. Thank you.
Oh. And that's, how you doing there? That's prosecutor. Yeah.
Okay, well, you said, Yes, I'm gonna go up there. Come right here. What's the other quorum? You don't need to go on call. It's 9 o'clock, my return. Yeah, I remember him doing it now, but.
Turn on, folks.
Are you ready to go?
Yeah. Yeah, no, yeah.
Simmons. No, Simmons locked up. So we wait on the.
Good morning, counselor.
Hi, good morning.
Are you ready?
Yes, and Mr. Ferguson, if you could text me your phone number, I'd appreciate it.
Yeah, you now?
What's that?
You want me to text it right now, sir?
Yeah, yes, please.
Text it to what phone number, sir?
My number is 248-866-6744.
1 second, sir.
Do you want me to put you in a breakout room?
Yes, that'd be helpful. Thank you.
Mr. Ferguson, accept the invite, please.
Yes, ma'am.
All right.
Where do I accept it? Okay. Okay.
You see it? All right. Oh, I'm sorry. Oh, here's Mr. Cohen. He's ready. Good morning.
Good morning.
Are you ready? You're on Townsend, correct?
Yes, ma'am. Thank you. Sorry, I was running late. Bunch of Zoom courts this morning.
Okay, he is on. You ready?
Yes, ma'am.
All right. Calling case number 2358759, the people of the state of Michigan versus Montez Townsend. Defendant is charged with count 1, weapons, dangerous weapon, miscellaneous. This matter is scheduled for a probable cause conference.
Good morning, Judge. This is Dan Duquette on behalf of the people, P number 86690.
And good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P 86151, appearing by Zoom with Mr. Montez Townsend, who's present by Zoom. Mr. Townsend, can you please state your name?
Montez Townsend.
Thank you.
Mr. Cohen, if you're gonna be late, just give us a call, please. I'll do these at 8:30. Right?
Understood, Your Honor. I apologize.
Thank you. I'll ask for a phone call.
Will do. I have discovery in this case, and I'm just asking to set the matter for an exam, please.
Okay. Are you available September 19th?
Yes, if the court has anything a little bit later in the morning, that would be fine.
To 11:15.
I can do that. September 19 at 11:15.
Anything else?
No, thank you very much, Your Honor.
Okay, thank you.
Have a good day.
That's in person, Mr. Townsend. Courtroom 233, September 19th, 11:15.
All right, same room number.
The room number is 233.
In person, Mr. Townsend, you got to be at 36th District, okay? I'll call you.
In person.
Yes.
All right. All right.
Thank you.
All right, thank you.
Right. What about Jackson? Anybody here on Jackson?
No one's here on Jackson except for, Plain. We have Mr. Coates and his attorney here for the 945.
Oh, Oh, Simmons is a jailer.
Right, so, yeah, he's in custody. Looks good last case here.
Don't go anywhere. You can ready to call it.
He says he's just gonna call him, Johnson, tonight.
Here's Jackson. Isn't it, right?
He's on Jackson.
Here's Jackson. He said everybody's here. Huh? Yeah. Hey, what do you say? I think they marked him as a jailer. Hmm? Yeah, normally I mark jailers in pink.
The other two, I think it's Brown and Dickerson. Might have two more. Brown and Dickerson.
Oh, yeah, they're right. I think they are. That's the.
That's good. This is courtroom 233. So there you go.
Who is this person in here that they will not?
Okay, I appreciate you. Thank you. So we got, they're gonna bring them in, right, when we got, Dickerson, Brown, and Deposit.
So they still didn't bring Simmons? here?
Simmons is here, but,
Oh.
they gonna bring them up in 2 more minutes, once they,
Okay,
take them off.
Jefferson's in 439. Jefferson's
Yeah,
in
yeah.
Jefferson's.
Yeah, right.
Jefferson's in Jefferson's courtroom. Oh, God.
Okay, Judge, the Diamond Turner, you're gonna have to call that because you can't agree to everything on Sullivan's, discovery order for discovery, some not discoverable information, and stuff that we removed the strike. There's no proof that something like that would exist in this case, and you got like 20 something. That I have to suffer. A lot of stuff that he's asking me to find a trial prosecutor on, and we're still in discovery as well.
Where's the cousin here?
Yeah, I need it, so.
Say something?
I can make you a copy of it.
Oh, what I wrote.
Ms. Jefferson starts on that
Well, come on.
now.
What about the other one?
I'm
Oh, okay.
about to just see, I wanted to see.
Oh, here, I'm sorry. You can.
Let's see if she in front of Jefferson.
No, they do not.
We ready on, Ferguson?
Yes,
Counselor?
yes.
All right, where is he on?
He might have.
Still in the breakout room.
Yeah, he was in the breakout room with me. He may not have figured out how to get back in. He might have to log back in.
Mr. Schulman, I do my PCCs at 8:30. If you're not gonna be here, please give us a call.
Okay, I'm sorry about that, Judge. I was trying to get him the additional discovery.
You want me to call it, waive his appearance?
No, who was on? Oh, here it is. Okay, he's coming on right now. Okay.
He still hasn't logged on. Oh, here he is.
Okay, good.
All right, here we go. Calling case number 2358739, the people of the state of Michigan versus Raphael Ferguson. Defendant is charged with count 1, home invasion, 2nd degree, habitual offender, 4th notice. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Agent Lewis for the people, P85520.
And good morning, Your Honor. Sanford Schulman, P43230, appearing on behalf of Raphael Ferguson, who's appearing by way of video conferencing with his consent and permission.
Ferguson, state your name for the record, please.
Sir, my name is Raphael Cortez Ferguson, sir.
Thank you. Schulman?
Yes, Your Honor. I'm not entirely sure what the defendant wishes to do today. He's indicated to me he wishes to hold the exam, but then he indicated he is prepared to waive the exam if the court modifies his bond to allow him to go to work. So
Deals.
Yeah.
You want to waive his exam, he can waive his exam, and you can address the issue of bond, but I don't make deals.
Right. Those are my exact words. Mr. Ferguson, how do you want to proceed? You want to set it for an exam?
No, sir.
Okay. All right. Then it's my understanding, Your Honor, that he wishes to waive his statutory right to a preliminary exam. I provided to him the discovery and the video, and we conferred a couple times. I apologize for the delay. I was sending him the video this morning, and he said he received it. And having reviewed all that, it's my understanding he wishes to waive his right to a preliminary exam and be bound over to the circuit court. If after the court accepts that waiver, I'll address bond.
People have any objection?
No, Your Honor, we don't have any.
All right, Mr. Ferguson, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause a crime was committed and probable cause you had something to do with committing that crime. You understand that?
Yes, sir.
Has anybody promised you anything or threatened you in any way to get you to waive your right to preliminary exam?
No, sir.
You waive your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes, sir.
Do you have any objection to the court signing your name to the waiver form?
No, sir.
Mr. Schulman, you have any objection to the court signing your name to the waiver form?
No, please do.
All right, the court will find that you freely and voluntarily waive your right to preliminary exam. Matter is bound over to Wayne County Circuit Court Criminal Division for arraignment on the information, which will be September 27th, 2023, at 9:00 p.m. All All right, you had an issue as to bond?
Yes, Your Honor. He's currently on a personal bond, I believe, if I'm not mistaken, 25,000. He has a tether as a condition. He's provided to me a letter from Sherwood Food Distributors and a contact name and number where he's employed, Steve Hollis. I have that number, and he indicates that he's unable to work because of the conditions, and he's asked for it to be modified to allow him to go to and from work. Also, he says he's a caregiver for his mother. I haven't been able to verify either, but he did provide a letter from Sherwood Food Distributors.
What hours does he work there?
Mr. Ferguson, what are the hours?
Yes, sir. I work from 4 to 10, but usually we do overtime, mandatory overtime, about 2 to 3 hours out the week. So sometimes I'm off from like 4 to 12.
I'm not sure if that's PM or AM.
PM, sir.
Okay.
Okay, I'm not gonna leave it open like that. I'm looking at your history. You have you got at least 4 prior home invasions. Then you got larceny, a number of larceny cases. You gotta have a bad habit of going places you got no business going.
So I'm not asking to remove the ankle monitor, sir. You can still monitor me 24 hours a day. I just want to go to work and pay my bills, sir.
Well, I'm not leaving it open for you to go whenever you feel like going. You gotta give me some.
Sir,
sound like I'm talking? Does it sound like I am talking?
I'm sorry.
You don't talk over me. You don't talk around me. If I ask you a question, you answer it. Do you understand?
Yes, sir.
People want to add anything in there?
Your Honor, pretty much on the same page with you, Judge of the court. He has a history of home invasions as well as this case involving multiple home invasions, allegedly. Yeah, Your Honor, I don't think that we could just leave it open to subject to overtime and things like that. If we have nothing concrete to know what time he will be there and coming right back from work, I don't think that, we could allow this.
Your Honor, maybe 4 till 10, and then he just doesn't work overtime.
He works 4 in the evening till 10 at night?
Yes.
What days?
Monday through Friday, sir.
All right. I'll give you from 3 to 11, that'll give you time to get back and forth.
Okay, thank you.
Have a, between 3 and 11.
3 and 11. 3 to 11.
Judge, does that complete this record?
Yep, that's
okay.
The record.
Thank you very much. Okay, Ms. Ferguson, I'll be in touch with you. All right.
Can you send me a copy of that so I can be able to go to work today and call the tether? Can you call the tether people and let them know I can go to work today?
Your Honor, would the clerk be kind enough to email me a copy of that order? Or do you want me to stop by?
Yeah, I'll email it to you in the tether unit.
Excellent.
Can
Okay.
you send me? I have your I think I have your email. Can you just put your email in chat for me, please?
Sure.
Just to make sure I have it. All right, thank you.
Thank you both. All right. All right, so I'll send it over as soon as I get it.
All right, thank you, sir.
Welcome.
Calling case number 2358433, the people of the state of Michigan versus Harris Jackson. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault, habitual offender for notice. This matter is scheduled for exam.
Good morning, Your Honor. Asa Lewis for the people, P-A-5520.
Good morning, Judge. Jeffrey Glazer, P 46892. I'm Mr. Jackson to my right, Judge. He is wearing a fez, Judge. That's for religious purposes. I'm asking the court allow him to do that.
All right, I recognize it. Sir, Jackson, can you state your name for the record?
Cars and trailer Jackson.
Thank you. All right, ready to proceed?
Yes, Your Honor. The people would ask for initial sequestration of any and all witnesses with the exception of the officer in charge in this case who was not testifying.
Agreed, Judge.
All right, any and all witnesses testifying will be the courtroom, including Zoom and or YouTube, or be denied their future testimony. Give a second to the officer in charge.
Thank you, Your Honor. At this time, the people call Robert Huddleston.
Robert?
My name is Robert.
Huddleston.
Yeah, would you stop? Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
All right, you pull the door towards you, sir.
That's one.
You pull the door right there in front of you, pull it towards you. You have a seat. All right, Mr. Huddleston, you're gonna be asked a series of questions. First by the prosecutor, and the defense attorney will probably ask you some questions. I may or may not ask you questions. All right, you have to answer all your questions out loud verbally using words. Just can't shake your head or say, you have to say yes, no, whatever the answer is, okay?
Yes, yeah. All right.
Also, when you're asked a question, I need you to listen to the question, answer the questions, then stop. All right? So if it's a yes or no type question, just say yes or no. If they need additional information, they'll just ask you another question. All right? We all have a tendency when we talk about something, especially if it's been traumatic, we tend to ramble. You know, because we want to get the whole story out. We say this happened and this happened and this happened and this happened. If you do that, I'm gonna miss something. All right, if I miss something, I might not make the right decision. Okay? That's why I know nothing about this case.
Right.
The only thing I know about this case is the defendant's name and what he's charged with. I know your name. I get all of my information from what happens in court. That's why we proceed one question, one answer, that way I can understand what happened.
Okay.
Okay? Okay. All right, thank you, sir. May proceed.
Mr. Huddleston, can you restate your name for the record?
Robert Drill Huddleston.
And on August 19, 2022, were you at 70114 Courtroom Street?
Yes, I was.
And what is that address?
Back one,
What is that address?
It's a hall.
Okay. And is that house in the city of Detroit, County of Wayne?
Yes, ma'am.
And did something happen at that address that brought you into court today?
Yes, ma'am. I was assaulted
Okay, and when you say you were assaulted, by whom were you assaulted?
by, I got his name, Carl Jackson, Mr. Jackson.
Your name,
You said Carlo?
Yeah, Carl Jackson.
And do you see the person who you're referring to here in the courtroom today?
Who that sitting down back there? I can't, can I get, can I?
Step up. Okay, you
Can I
can
step
step
up?
up. Okay.
Step
so
up
you
to the
can
front
see.
of the.
Y'all caught my eyes. Yeah, that's him right there.
Can you identify an article of clothing he's wearing or a color or something? The
Clothing
person you
what?
just pointed to, can you identify a color or something that he's
The
wearing?
them dark clothes on with the head. You know?
Your Honor, may the record reflect that the witness has identified the defendant. Okay. Now, you said he assaulted you. Were you inside of this house or outside?
I was outside.
And how did he assault you?
He had a couple sticks, yeah. I came from the store. He was here to have a wood fence. And when I came past the wood fence, he came out with 2 sticks in the head and the hand and started beating on me.
Okay, now did he say anything to you?
No, he just went to beating on me.
Okay, and when, you said 2 sticks and then, was that 2 sticks in each hand?
Yeah, he had a stick in each hand,
And how big were these sticks?
not that long,
Okay, is that about 2 feet maybe?
about a foot.
A foot to 2, okay. And, did he, you said he assaulted you with these, where did these sticks hit you?
Well, the first lick he hit me upside the head. It caught that about 5 stitches there, and then he kept trying to hit me in the head. I had to sacrifice my hand to save my head, but every lick he was trying to kill me, hitting my head. He scarred my hand up, but he managed to hit me behind my head twice. And after then, I was almost out of it. He knocked me to the ground and left me laying in the street. And I saw him running away, but I was dazed.
Okay, okay, so, at what point did you see who it was that was hitting you?
After he come up behind the wood fence and with the hitting on me.
Okay, and you could clearly see his face as he was hitting you?
Mm-hmm.
Okay.
Say yes.
or no?
Say yes or no.
Yes.
Thank you.
And did he say anything as he was running away?
No, he ran away and left me laying in the street.
Okay.
You know?
So, did this start in the street?
No, it didn't start there. The confrontation started at 1733 in front of my house. We got the argument by my lawnmower.
Okay, so something happened prior to,
Yeah.
what happened at the 70114 Churchill Street?
Yeah.
Okay, and you said you were coming from the store when this occurred? Is that correct? You were walking from the store when this occurred?
Yes, I was walking from the store.
Okay, so you know who this person is?
Yes, I know him.
Okay. And how long have you known him?
I've been knowing him about a couple of years.
Okay. And you stated that you were laying in the street and you said you were kind of dazed.
Yeah.
Did you ever get up?
No, my eyewitness one live there. He helped me get up off the street.
So somebody helped you get up off the street?
Mm-hmm.
Okay, and then
Yes
was
or no?
Yes.
Yes.
Are you okay? You holding your chest?
No, I have a heart problem. You know, every time I think about this case and I have seizures, man, I'm really tempted to I gotta take it easy because when I get upset, to lead on to a seizure. I don't have a seizure in the courtroom.
Okay, so you have seizures not because of your head injury, but because of you being upset?
I have seizures from my head injury. I have never had a seizure in my life.
Okay, you started having seizures after you was hit in the head?
Yes.
Leading judge.
Okay. Yes, sir.
Yes.
No, I mean,
Okay, strike
they
that.
already kind of repeated what he just said.
Oh.
Hold on, go ahead.
Okay.
Anything else?
No further.
Just a few questions, sir. Who lives in, do you live in 7014 Courtroom?
No,
My question, sir, do you live in 7014?
no, I don't live there.
Okay. What were you doing there, sir?
I was coming from the store from paying my lottery.
You got into an argument with Mr. Jackson earlier that day, correct?
Yeah, at 1732 we had the argument. I left it alone.
And that, is that your house or Mr. Jackson?
In front of my house.
And you're indicating you're struck twice, is that correct, sir?
I was struck 3 times and all. More than 3 times, hit me in the front of my head, my head and knocked me down, but he kept trying to hit me in the head.
Sir, my question to you, sir, my question to you was, you indicated earlier that you're struck twice. Are you changing your testimony?
No, that's not what he said.
But that's what he said.
No, that's not what he said.
How many times were you struck, sir?
I was struck, let me see it, and all, once in the front and 2 behind. And they kept trying to hit me. I blocked the stick with my hand, guard my hand up. So they were literally trying to hit me in the head.
So, sir, is your answer 3 times?
Huh?
Is your answer 3 times?
3 times. I said 3 times.
Right, your answer is more than 3 times.
Yes.
So he was struck in the head 3 times, he was struck on the hand several times.
Yeah.
Where he's trying to block the blow.
Yeah.
So he was struck several times.
Did you have a chance to talk to the police regarding this incident, sir?
Say it again.
Did you have a chance to talk to the police regarding this incident?
Yeah, the police came out on the scene.
And how many times did you tell the police you were struck, sir?
Well,
and Khalil got on the green.
And Judge, may the record reflect, he has identified the defendants in this case. Thank you, Judge. So you indicated you went with these three to a bar. Approximately how long did you stay at that bar?
Until it closed.
Okay. And where did you go after that?
If I'm not mistaken, the Martez house.
Okay. And is Martez's house located at 6719 Auburn Street?
Yes.
And is that in the city of Detroit, county of Wayne?
Yes.
Okay. And why did you go to that address after leaving the bar?
To drop Martez and Dickerson off.
Okay. And upon arriving at that location, did anything happen that brings us into court today?
Yes.
Okay, and what happened at that location?
I think when I got out for like 10, 15 minutes after us getting out, when we made it to the house.
And let me back you up just a little bit here. So you indicated about 15 minutes after arriving at this location, you said us. Who do you mean by us?
Me, Dickerson, Martez, and Khalil.
Okay. So what happened 15 minutes after arriving there?
After arriving there, Dickerson swung on me. I moved and we started fighting. And then Martez and Khalil ran up on me and we all started. I just started fighting. It was hard to start fighting. Okay. Punches everywhere.
Okay. So were they fighting each other or were they just fighting you?
No, that's me.
Okay. And did any of them have anything in their hands?
No, I know, but I know Martez and Dickerson had guns on.
Okay, you know they had
Objection,
guns.
Your
Honor.
I think it's lack of foundation.
Well, he's saying what he knew, so, I mean, you get the right to cross-exam, and I'm sure the prosecutor will delve into the issue, so at this point, I'm gonna take the answer.
Thank you, Judge.
Okay.
How did you
back
know?
up, folks? 'Cause you gotta slow down. I got three defendants here. I gotta keep track of all three of them.
Certainly.
So when you go through it too fast, I'm gonna miss something.
Certainly.
Okay. You said you said you knew someone had a gun on them.
Yes.
Who was that?
Martez and Mr. Dickerson.
Okay, go ahead.
And how did you know those two had guns on them?
And the car, the security guard told them they can't have me when they had to go back in the car.
Okay. And did they put it back in the car at that time?
Yes.
Okay. And was that the car you drove back to the 6719 Auburn Street address in?
I didn't drive, I was in the passenger.
Was it the same location that
Yes.
the four of you traveled? Thank you. And let's go back to the fight. You indicated you didn't see anything in their hands. Okay. And
Did he answer?
I'm sorry, please.
I apologize. No, you're right. No, I indicated I didn't see anything.
Thank you, sir. So while this fight is going on, what happens?
I started losing, I lost my glasses. I was trying to get away. As I was trying to get away, ran down the street. In the midst of me trying to get away, I got hit by a pole.
So let's go back a little bit here. You indicated you lost your glasses. Where were your glasses at the start of this?
On my face.
Okay. And you lost them, were they dropped? Did you drop them?
They fit tight on my face, so I couldn't feel.
Okay, what happened to them?
Someone took them off my face.
Okay. And did you lose anything else during this encounter?
My phone, well, it's not even my phone, it's my mother's phone, and my shoes.
Okay. And where was your phone? Okay. And you described a pair of shoes. Were they shoes you were wearing or?
Yes, they was black shoes. They look like Nikes, but they wasn't. They was work shoes.
Okay. Now, you also indicated that at some point a metal pole was involved.
I didn't hear anything about a metal pole. I heard something like getting hit with a pole, that was it.
Certainly, Judge.
Get it from him, not from you, please.
Certainly, my apologies, Judge. You described a pole was involved during this altercation.
Yes, like I said.
And let me stop you there. Did you witness this pole at any point?
I didn't witness it, but I felt it.
Okay, and you described feeling it. Can you explain what you mean by that?
Like a hard object, like a hard circular object.
Okay, did it make contact with you?
Yes, my back.
Okay, and when was this? Was this at the start of the altercation or near the end of it?
Near the end.
Okay, so after being struck with this object, what did you do?
I tried to run. I ran. As I was running, I heard gunshots. I don't know if I was getting shot at or if it was just in the area or not, but I heard gunshots. I ran to someone's house, knocked on their side door, acting like it was my family, my cousin, couldn't get no help. I started jumping the fences.
Okay, let me stop you there. At some point, did you end up getting away from the three defendants in this case?
No, I slept in someone's backyard, laying down in grass overnight.
And were you ever able to recover your shoes, cell phone, or glasses?
No.
Did you make any attempts to recover those items?
No.
You indicated that you were running to, was it a family member's house you ran to? Okay, and
Yes or
why?
no? Yes or no? Yeah, I'm sorry, yes.
My apologies. You indicated that you were running, so why did you continue to run?
I was trying to get away.
Okay, and trying to get away from who?
Martez, Khalil, and Mr. Dickinson.
Were they still chasing you?
Yes.
Nothing further this time, Judge.
Thank you, Judge. Good morning, sir. I'm going to be asking you some questions. If you don't hear me or don't understand my questions, let me know, okay?
Yes.
All right. You had indicated that you had met with Mr. Dickerson, Mr. Jackson, and Mr. Brown, correct?
Yes.
And do you remember what time the three of you got together, or the four of you?
It was like around like 8, 9. It was dark, but it wasn't too late because we had left the bar late.
Okay, so how do you get picked up?
Yes, I got Khalil picked me up.
Okay, and how do you know them?
I went to high school with them.
Okay.
Okay.
Okay, and so you get picked up, so there's this arrangement for you guys to hang out, correct? And
Yes or
who
no?
was driving?
Yes.
Who was driving?
Khalil.
Now, you say that you had left the bar very late. Do you remember what time or how many hours you stayed at the bar?
I want to say like around 1 or 2 hours. Like I said, we shut it down. Like, we stayed until they closed.
Okay, did you have any drinks at the bar?
I had a lot. I didn't have no money on me at the time either.
Okay. What did you have to drink?
Your Honor, I would object to the relevance of that question.
Why would it be relevant?
It was liquor.
Hold on. It's relevant as to his, how drunk, if he was drunk, I'm not saying he wasn't. To know how much he had to drink, may affect his ability to recollect and know what was going on.
Go ahead, sir. What did you have to drink that day?
I can't remember the type of liquor. It was liquor.
Okay. Do you remember how much you had of that? You said you had a lot. Do you remember? To the point that you can't remember how much you had, correct?
Yes, ma'am.
And is it fair to say that you had started drinking from the point that you got to the bar up until the point that the bar
Yes.
closed?
Yes, ma'am.
Okay, thank you, sir. At some point, you, Mr. Dickerson, Mr. Brown, and Mr. Jackson leave the bar, correct?
Yes, ma'am.
Okay. You indicated that you went to Mr. Jackson's house in order to drop him off, correct?
Yes, ma'am.
All right, and who else were you dropping off?
Dickerson.
Okay. At some point during that car ride, was it you and Mr. Dickerson that got into an argument?
We never got into an argument.
Okay, so when you arrive at Mr. Jackson's house, do you get out of the vehicle?
Yes.
Okay. Does everybody get out of the vehicle?
Everybody got out of the vehicle.
Okay. So uninstigated, everybody just starts beating on you?
No, and everybody got out the vehicle. As we was walking up, we was talking about this group of ladies that we was talking to at the bar before we left. And a person that's talking about that, Dickerson just started to ask like, "Where's my 20?" And I'm like, I'm intoxicated. I just met up with them after so long of being with them. I'm lost, don't know what he talking about. So, what you mean? And he swung on me. After he swung on me, he put the gun in front of me, and he like, we start fighting. After we start fighting, Martez and Khalil ran up and we all started fighting each other. Then it went from there and we went and started going down the street. And that's what I say. I mean, that's when I say, at the time when we was migrating down the street, we were trying to get away. The process of fighting, there was a pole that I hit my back.
Okay.
Wait, I have to clarify it, please. You said that Defendant Dickerson swung on you, and you started fighting. And then that Defendant Jackson and Defendant Brown then ran up, and you said you all started fighting.
Yeah, like that.
What does that mean?
It was me against them.
So
I was fighting them.
Y'all weren't fighting, they were all fighting you.
Yes.
Okay. All right. I want to clarify it. Thank you.
Sir, you can sit back too. We're picking up a lot of feedback. You can sit back.
Okay. Sir, do you remember that did you go to the police after this?
Yes.
And when did you go to the police?
Right after.
All right, and was it the second day?
Yeah, the next day.
All right, did you go to the precinct?
Yes.
Did you speak with an officer?
Yes.
When you spoke with an officer, was a written statement taken?
Yes.
And you had signed you made a statement and then you signed and dated it, correct?
Yes.
Okay. When you spoke initially with the officer at this precinct, you had never mentioned the details of what Mr. Jackson did exactly, correct? And you've never mentioned at that time that you've ever seen him with a gun, correct?
I did. I believe I did.
Okay. Do you remember being asked specifically in your statement if you had seen anybody with a gun?
Yes.
Okay. And you gave a response. And you indicated that 6 had a gun. Who is 6?
Mr. Dickerson.
Okay. You never mentioned in your written statement that Mr. Jackson had a gun, correct?
I don't recall that.
Okay. Would you like to review your written statement real quick? Maybe it'll help refresh your memory. Yes?
Yes. Yes.
Judge, may I approach?
Yes.
All right, sir. I'm handing you this if you want to just look at it and let me know if you recognize it. Does it have your name at the top?
Yes.
Is that a statement that you've made? Do you see your signature at the bottom?
Yes,
And is it dated?
yes.
Okay, please review it and then let me know when you're done. Do you want to review the entire statement and then let me know when you're done? Are you all set, sir?
Yes, I'm done.
Judge may approach to get the
Yes.
paper. Thank you, sir. Sir, nowhere on this do you indicate that Mr. Jackson ever had a weapon, correct?
Right.
And sir, this was signed by you on June 26, 2023, the second day, correct?
Right.
Now, you indicated that you also felt being hit with something, correct? You don't know who hit you, correct? And you don't know for sure.
You're gonna answer
Oh,
out
I'm
loud.
sorry.
Correct, correct.
Thank you. And you don't know for sure what you were hit with, correct?
Correct, I didn't know, I felt like it was a phone.
That's what you,
I do home stuff, like work on houses and all, so I know it feels like a phone.
okay, but you didn't see it, correct?
No.
All right. Sir, you also indicated that while you were running, you had heard gunshot, but you weren't sure. It could have been from the neighborhood, correct? Okay. But you weren't certain where it was coming from, correct?
Correct.
One second. Judge, nothing further at this time.
Good afternoon, Ms. Anderson. I just have a few questions for you. You indicated that all three of you had gone to high school before, so you knew everybody. Is that
Yes.
correct? And you consider yourselves as all friends at that point, correct?
Yes.
And at some point in time, the three of you agreed to go and hang out that night, correct?
Yes.
And the decision was made to go to a bar, correct?
Yes.
Prior to going to that bar, had you or any of the others that you recall consumed any drugs, be it marijuana or anything else?
No.
You
Not prior to going.
Excuse me?
No, sir, not prior warrant, but when we arrived and got there, yes.
That was my question. So when you arrived and got there, you all smoked weed or did some sort of drugs?
Yes.
What was it?
Marijuana.
Was that including you as well?
Yes.
And that was before you went into the club, correct?
No.
While you were there?
Yes.
Inside?
Yes.
Okay. So also you indicated while you were in there, in addition to smoking, you were also drinking and that you admitted that you were drunk, correct?
Yes.
Okay. Now, at some point in time, you say you left about 3 o'clock in the morning. The three of you, well, first, let's go back a little bit. You indicated that when the three of you are all trying to get in, security guard said 2 individuals couldn't go in. They had to get rid of their, as you said, weapons or something, right?
Yes.
You didn't see those weapons at that time, did you?
No.
You were only,
but
you only heard that from the security guard person, correct?
Yes, and it also came up.
Please just answer the questions that I'm asking, all right?
Yes.
After that, those 2 individuals left out from where you were to a car or somewhere to get rid of whatever they had in your mind. Is that correct?
Correct.
Okay. They came back and they were able to get in the club. Is that also correct?
Correct.
Okay. So some point in time, you all leave, you all get in the car and you're riding, going over to whose house was it?
Martez, I believe.
Okay. Conversation in the car was talking, you all were talking about the women that you met in the club and that sort of thing, correct?
Correct.
No arguing, no nothing.
Correct.
Okay. You all get out of the car. By then, it's well after 3 o'clock. And you say, out of the clear blue sky, that my client just ups and Mr. Dixon just ups and swings at you, correct?
Correct.
No discussion at all about why or anything before he swung?
No, it was.
Were you all arguing before he swung?
No.
No arguing?
No.
So would it be fair to say, as far as you know, you're just there, and he swung and then the 2 of you all started fighting, correct?
Correct.
Okay, and where did this happen?
In front of Martez's house.
On the front grass, on the porch, on the, where?
On the sidewalk.
On the sidewalk, okay. Is this a corner house, by the way?
No.
Okay, so the whole fight activity took place right on the sidewalk in front of that house, correct?
Correct.
Now, in the course of that fight, you say you had your glasses on, right?
Correct.
And at some point in time, well, first let me ask you this. Isn't it fair to say that during the fight, your glasses got knocked off?
No. No.
No? Well, you know who took your glasses off, do you?
I mean, no, I don't physically know who took them off, but I know they got taken on my face.
Well, who took your glasses off? If they're on your face, you're able to see, who was it that took your glasses off?
Yes, sir, I'm not for sure.
You don't know, do you?
No.
Isn't it fair that in fact, during the fight, your glasses got knocked off?
Yes.
All right. Let's talk about your shoes. Now, you said at some point you felt 3 people on top of you while you're, let me ask you this way. At some point, it was just you and Mr. Dickerson fighting, correct?
Yes.
Would it be fair to say that while the 2 of you were fighting, at some point in time, you ended up on the ground?
Yes.
While you were on the ground, were you covered up? So you could not, so your vitals weren't hit, or maybe I'm putting that a bad way, but were you on the ground covering up while you were being, as you say, hit?
Yes.
Would it be fair to say that at that point in time, you felt as if you were getting hit by 3 people as opposed to 1 person?
No.
So were any words being said to you by anybody that you could recognize?
Mr. Dixon kept asking for his $20.
Okay, other than that, you couldn't hear the voices of anybody else, could you?
No.
During that fight, somehow your shoes came off? Is that yes? How did your shoes come off? Just during the fight, right?
Right.
Nobody took your shoes off, did they?
No, they came off.
All right. Now, same thing with the phone. Nobody reached inside of your pocket and pulled that phone out, did they?
Yeah, my phone didn't just come out of my pocket.
Well, who took your phone out?
I don't know, there's a lot going on.
So you don't know who, you didn't feel anybody pulling the phone out of your pocket?
Yes, I did, but I don't know who. It was a lot going on.
What position were you in when you say you felt this phone? Were you on the ground?
No, I wasn't.
You were up standing up?
Yes.
If you're standing up and you're fighting Mr. Dickerson, you can't tell this court who it was that pulled.
Excuse me, sir, I'm highly intoxicated to barely stand on my feet.
So that would affect your ability to observe and recall what happened at that time, correct?
I know what happened.
Well, you don't know who took, as you say, you don't know who took this phone out of your pocket, correct?
Correct.
And that was why you were standing up?
Correct.
Okay. Now, you indicated that at some point in time, you got up and you started running. Did you turn around to see if anybody was chasing you?
Yes.
How far did you run from? You in front of the house, how far did you run before you ran up on somebody's doorstep?
Running, at least like a house, like not even a whole house in between.
So let me understand this. Correct me if I'm wrong. You're down on the ground covering up. People are beating on you. At some point in time, they stop beating and you get up and you ran not even a whole house away. Is that fair?
Right across the street, and I started jumping. I jumped the gate, and that's how I hit it in the driveway on Minnock.
Okay, let's take this a little bit at a time. You're on the ground. At some point, they stop beating you or fighting you, correct?
No.
Okay, while they're fighting you, you get up and you run across the street?
Yes.
Who's behind you at that point in time? Do you know?
6. Mr. Dixon.
Just Mr. Dixon. Not the other two people.
They all in, Mr. Dixon was closer.
Okay, and you ran across the street to a house?
Yes. I hopped the fence.
Oh, you hopped the fence. Did you run between houses?
Yes, I did.
And
In the process of that, Mr. Dixon was right there with me, chasing me.
Okay, so, at some point in time, you say you laid in the grass, correct?
Yeah, that was after I knocked on the door, and whoever stayed in there, I pretended as if they was my family. Said, cousin, open the door, open the door.
Okay, let me stop you right there. When you're there knocking on the door, saying, open the door, you didn't see anybody around you, did you?
Yes, I did. I seen Mr. Dickerson, Khalil, and Martez, all at the end of this man's driveway.
Where were they?
At the end of this man's driveway, telling me that's not my family, leave the house, so they can beat my ass.
Okay,
Excuse my language.
Okay, right there, you say you left and you went and hid in the grass somewhere?
Yes.
Nobody approached you while you were hiding up in this grass, did they?
Yes.
Who approached you?
Mr. Dickerson.
You didn't tell us to the police in your statement, did you?
Yes, I did.
You said that while you ran and you hid in the grass, Dickerson approached you then? This is after you knocked on the door.
When I was trying to get away, that was in the process of me trying to get away. I had to hop 3 different yards in the backyard fence just to get away. The grass was high, so I laid there.
Sir, I'm not trying to confuse you and I don't want to beat a dead horse here. I just want to get clear. After you knocked on the door, you said you ran and hid in the grass.
And Mr. Dickerson,
is that yes or no?
Yes.
How far away from the door did you run before you hid in the grass?
That wasn't far. It was right in the backyard. I'm on the side of the house, on the side door. The backyard is right there.
So you hid in the grass in the lot next door to the house, correct?
Yeah, that was at the end of everything.
That's it. Okay. no one, and you stayed there until it got light out,
Yes,
correct?
till the next morning.
Nobody approached you or messed with you while you were hiding in those weeds, is that correct?
Correct.
Okay. When you got up, you didn't go look for your shoes, your phone, or your glasses. Is that also correct?
That's correct.
Thank you, nothing further.
Good morning, or afternoon. Mr. Henderson, it sounds like all of this happened at about 3 o'clock in the morning. Is that fair to say?
It's fair to say.
Okay, and at what time did you go to the police station to report this?
7, 8, it was early.
So after you left the area where you were sleeping in the grass, where'd you go?
I walked down the street, and I was knocking on the house, knocking on people's houses, trying to get a phone so I could call, get a ride. And this lady ended up letting me use her phone. And I called my mom, she didn't answer, called my aunt, she didn't answer. And I called my aunt again, she didn't answer. And I was the lady, I ended up coming back to the door telling me that my aunt called back. And that's how I was able to get a hold of someone and leave.
Okay, and if I told you you gave a statement at about noon, would that sound about right to you?
Yeah.
Okay. And I believe you testified earlier that you had a lot of drinks, you can't remember how many, and you were drunk that night, right?
Right.
Were you drinking liquor that night?
Yes.
Okay. And you were drinking up until the bar closed at 2 a.m., right?
Yes.
Okay. I believe you testified earlier that you were smoking marijuana that night, right?
Yes.
Were you doing any other drugs that night?
No.
Judge, I would object, ask the answer.
Your Honor, for what it's worth, I don't know if the question about.
First time asking answer, so.
Thank you. Thank you. And then like you went to the bar with your friends voluntarily that night, right?
Are we gonna repeat the whole testimony all over again?
No, Judge, I'm not, and I'm certainly not. And that night, the individuals you were with bought food and drinks for you, right?
Yes.
And nobody asked you for any $20 or anything up until that point, right?
Yes.
After this incident, you didn't get any sort of medical treatment, right?
Yes.
You did?
Yes.
Where at?
Well, no, you're talking about like being broken, no. I just went to the doctor and ER to make sure I was okay.
When did you do that?
The same day that I had a concussion.
What kind of pants were you wearing that evening?
White pants.
Were they jeans or stretchy pants?
They were stretchy pants with colorful, like different colors on it.
Did they have zipper pockets?
Yes.
Okay, and your phone was inside of that zipper pocket, right?
Yes.
Judge, if I could just have a minute.
Sure.
Nothing further, Judge.
Sorry, Judge.
Redirect?
Yes, Judge, briefly. You testified that you were wearing you were wearing pants with zippered pockets. And were those zippers zipped?
Yes.
Was your cell phone inside of one of those zipped pockets?
Yes.
You testified that you can not remember how much you had to drink, but you can remember this incident.
Yes,
Why? Why can you remember this incident, but not how much you had to drink?
because, loving about the way they distribute their drinks, it's like a whole bunch, it's like one big platter with a whole bunch of little small cups filled with liquor in it. So I don't know how many of the small cups I have, but I know I had a lot. It's not like you got the whole bottle and you can see how many bottles you're drinking or how much of the bottle you drunk.
During this altercation at 6719 Auburn, did you ever see a gun?
Yes.
When did you see a gun?
Before the fight started. After the beginning.
Hold on, wait. What's the objection?
It's asked and answered.
I'm asking specifically if you saw a gun at this address.
No, I'm gonna allow it. Objection overruled.
So I'm gonna repeat my question. Did you ever see a gun at the address 6719 Auburn Street?
Yes.
When did you see it at that address?
At the beginning of the fight.
Okay, and where did you see that gun?
On Mr. Dickinson.
Okay, what was he doing with that gun?
Pulled it out of his jacket or his waistline and put it into his pocket.
Did he say anything at that point?
He was keep asking about the $20.
Nothing further from people this time, Judge.
May I redirect?
No, on behalf of Mr. Jackson.
I have a few here. So you're saying that before the fight started, you saw Mr. Dickinson pull out a gun and put it in his pocket?
Yes. If I'm not mistaken, I don't remember, but I remember that part, but I don't remember if I was, like I said, I was intoxicated. I don't remember if I had said something about him shooting me with the gun or something, because I knew he had a gun on, or something, but I said something to him, which made him take it off his hip and put it inside his pocket.
Are you dreaming or thinking you said that?
Judge, I would object to that question.
Well,
no, I mean, I think the question is appropriate under the circumstances. He said he was drunk. He remembers parts of it. He doesn't remember other parts of it. You know, so I'm going to allow the question if you can answer it. But actually, he did. He said no. I remember seeing that.
You testified on what they call direct exam, that out of the clear blue sky, my client just hit you, and then that's when the fight started, right?
No.
You didn't tell the judge that?
I said he asked was 20. He asked was money.
You didn't say he hit me out of clear blue sky and then he started asking for the money?
No, his testimony was, as it said.
Okay.
His original testimony was as that he said that Mr. Dixon asked him where was his 20. And then he got here.
Thank you. Now, nowhere during your testimony did you mention anything about Mr. Dickinson pulling out a gun and then putting it in his pocket. When did you say that happened?
It happened at the incident. What do you mean when?
I mean, I think you told the court that you aren't clear when that happened, or maybe even if that happened at all.
No, I said I wasn't clear, or maybe if it didn't happen, if I said something to him regarding putting his gun up. But I know for a fact he put his gun up because I visually saw it.
Okay, let's talk about that just for a minute. When did he do that?
Before he swung on me.
So before he said anything about anything, while you're all on the front porch, is it your testimony?
We wasn't on the front porch, we was on the front line, not even the front line, the sidewalk.
I'm sorry, on the sidewalk, before he said anything to you, you saw him pull a gun out
That's
of.
why I said, I don't know if I
Please.
said something to him because it was already starting to get to that point. So I don't know if I said something to him or if he just grabbed it and put it in his pocket, but I know I visually seen it. Then after that is when I tried
Slow
to
down,
get swung
please,
on.
please, let's take this in small bites. Before he did anything, is it fair to say that you're saying now that you saw him pull a gun out of his waistband and put it in his pocket?
Yes.
And that happened while everybody was around and you were on the front sidewalk,
Yes.
correct? And then after that, that is when he swung on you or asked you for $20 or something like that?
Yes.
And then that's when the fight happened?
Yes.
One other thing, as it relates to the phone. There was an attempt to return this phone to you, wasn't there?
When?
After this incident happened, wasn't there an attempt to return the phone to you?
Not to my knowledge.
You weren't sent a text message about picking up your mother's phone?
Not to my knowledge.
If I show you something, you think that might refresh your memory?
Mm-hmm.
Is that yes?
Yes.
May I approach, Your Honor?
Well, what are you showing?
Judge, I would object as to the ambiguity as to what phone this text was actually sent to.
Judge, this came out of discovery. Not only that, but I can show him anything in the world to help him refresh his memory. He can tell me it doesn't or does.
Yeah, but we have to know what it is, where it came from, the whole bit.
He can do all of that.
Huh?
He can do all of that. He can say whether or not he recognizes. This is out of discovery, Judge. Their discovery.
The
That
phone?
they gave, no, not the phone, what's on the phone. This is part of my
You
discovery.
got okay. Let me make sure I understand, because I wasn't understanding. I thought you were gonna show him a text message that.
That's
was
what it
on
is.
That phone, hold on.
Oh,
on that phone
I
there,
understand.
not a picture of a text message that was provided to you in discovery that's on the phone. It's two different things.
I wasn't clear, Judge. I'm sorry
Okay, so
about that.
I'm assuming it's the latter, right?
Yes,
It's a
it is.
picture of a text message that was provided on some document that was provided in discovery.
That's correct.
Okay, I got it. What's your objection?
Authentication as to which phone it was actually sent to.
Well, I mean, he could, that has nothing to do with refreshing his memory. I mean, he can look at it and make a determination if it refreshes his memory, if he got it, if he didn't get it. I'm gonna allow it, go ahead.
Thank you. Yeah, approach.
Yeah.
Please review this and tell me if you recall this at all.
Yes, I do.
As a matter of fact, what I showed you was a text message. This is something that
Hold on. You said yes, you do, yes, you recall receiving a text message, or you recall the?
Yes, I'm receiving a text message, but I never made arrangements to go get the phone. That text message, that's not even a text message saying you can come, that's saying you come get your phone, but it's a threat at that too. What just happened? Who really wanna go get their phone back on the same location that just happened?
if I can make it brief.
All right.
Okay, first, let me read this text message into the record. On top it says.
Before, I would have to have, somebody got authenticated.
And it's a lot more.
Hold on. This is my job, yeah.
Maybe we can do it this way, Judge. I think it may work. Mr. Henderson, this alleged text message that I sent you, that I showed you, did you send this, did you give this to the police?
Yes, yes,
You downloaded this message from your mother's cell phone and you gave this information to the police.
no, that's on Instagram.
You downloaded from Instagram.
Took a picture, I took a picture and gave it to the police.
Yeah, I believe that at this point, this might be authenticating enough. If this witness says that he pulled this information off of Instagram and gave it to the police.
That's
Hold on, wait, just one.
Judge, we still don't know to which Instagram account this actually would have been sent to. If it was
That doesn't matter. What do I care about that? What I care about is whether or not he has seen this, where he's, you can cross-examine us to, or go back to redirect and question him on it if you want. But, the issue is the information received, the information he provided. And that's what I'm getting out of it. He provided this information. So, and it was used to refresh his memory. So I'm gonna allow it. Go ahead.
Thank you. Isn't it true, since you say that you got this off of Instagram and it came to you, isn't it true that this was from a person you know as Slim, correct?
Mr. Dickerson.
That's Mr. Dickerson. And it says, question, this tell or his people's? Then it says, bro,
What? Say that again?
this tell or his people's? It's a question being asked, whether or not is this tell or his people's. What's your nickname? They people call you Tell?
Yes.
Okay. So would you agree that this question is this Tell or his people's? What does that mean to you?
It's a question. He asked me something.
What does that mean to you?
It's a question. He's asking me something.
He's asking if this text message is the receiver you or your people.
Right.
Okay. Then it goes on to say, bro, stop trying to play shit crazy and come get your mama's phone. Then it also says, man, get this phone. I'm not fitting to play with you. Ain't nobody gonna kill you. Not over $20. And then it goes on to say, but your phone gonna be a Tez shit. That's all I wanted to tell you.
Repeat the last one more time.
But your phone gonna be at Tez shit. That's all I wanted to tell you. You got this message, right? Is that yes?
Yes.
And you understand that to mean that they wanted to return your phone? Yes or no?
They or he is, it's not coming from a they.
Or he, I'm sorry. He, the person that you knew as Slim, as Mr. Dickerson.
I don't know if he wanted to return my phone or wanted to do more.
But that's what this.
There's more to that.
I'm not asking you about this, sir. That's how you took this message, correct?
Yes, because there's more to that. It's just not that.
Thank you.
Hold on. I need you to because I don't think he gave the answer that you thought he gave.
He said there was more to it.
To it, correct. You asked him, your question was it his opinion that what Mr. Dickerson was asking him was to come get his phone? And he kept saying there's more to that, which means he's not saying, yes, that's what Mr. Dickerson was saying. At least not in my opinion, what his answer was. So when Well,
I can.
you need a question, or I can, I mean, I gotta clear it up one way or the other.
I can adjust it. Is it your thought that you didn't want to get that phone because you thought you were gonna get beat up again?
Oh, no. I could have went and got that phone. The police had told me myself not to even go back and get the phone.
Is that why you didn't go back and get the phone?
Part of the reason.
There's another reason?
No, that's the reason.
All right. I think that answers the board's issue.
Any redirect?
Yeah, he said.
Well, Brandon, you got anything?
Yeah.
You were asked some questions on direct about, or redirect, about your, pants being unzipped or zipped. But isn't it, you were intoxicated that night, you were smoking marijuana that night. Isn't it possible that your pants, pocket was actually unzipped?
No, because I only carry my wallet and my phone. So that's important to me. I ain't got time to be losing that. I got a wallet that has my social security card, all that, too much information.
So your wallet was with your cell phone that night?
So
okay.
If my pockets was unzipped and my wallet, I mean, my phone just fell, my wallet should still be in my pocket. You get what I'm saying?
But you left with your wallet that night?
I got my wallet on me, same wallet. Yes.
So you left with your wallet that night, your wallet was still in your pants pocket when you left that night, right?
Yes.
And you weren't using your phone at all during this altercation?
No.
Okay, and it's not possible that, at some point you pulled out your phone to try and use it during this altercation?
I mean, I might have tried I tried to call my mom.
Okay, so at some point during this altercation, you pulled your phone out of your pocket, your zipper pocket, and you tried to use it, right?
Right.
Okay, and then isn't it possible you could have dropped your phone at some point during that altercation instead of putting it back right into the zipper pocket?
Speak yes.
You gotta answer.
No.
No. Okay.
Mr. Henderson, what was in your wallet this night?
Everything.
What does everything include?
What's the relevance of which things you're gonna waive,
This would be as to why it would have been left on his person, Judge.
We already said that. I got that in the beginning of the testimony, that he didn't have any money on him when he went there.
Bro,
You said that earlier.
Everybody did. I didn't have any money.
Upon receipt of the message that you were approached with, what did you interpret that message to be?
Probably trying to get me to come back over there and do more to me. Ain't no telling. They was making videos on Instagram lives, talking about how they set me up and everything. So there's no telling. That's why I say it's more to it. You can't just go off that because that's nothing. That's not even showing the videos and nothing that they was making. So it's just more to it. That's why I say that's why I didn't go get my phone, because there's more to it. And then when I told the police, they told me not to go.
And who did this message come from?
Mr. Dickerson.
Nothing further, Judge.
Anything further?
No cross.
Nothing further.
I think it was covered, Judge. Thank you.
All right, thank you. You can step out.
No further witnesses from the people, Judge.
No, not on behalf of Mr. Jackson.
No witnesses.
No witnesses on behalf of Mr. Brown.
Judge, the people would move to bind over on all counts, and as to count 1, robbery armed, we would move to bind over, if not count 1, then the alternative charge of robbery unarmed, contrary to MCL 750.530. And Judge, as the argument, in this
Where are you
case,
getting the unarmed robbery from? I don't see an unarmed, this is all or nothing. You know, and I would assume that the armed part comes from this hard metal pole, which was used as some type of weapon. But to get past the armed robbery, you have to show an intent to permanently deprive.
and Judge, as to that intent to permanently deprive, first and foremost, we heard testimony from Mr. Henderson that during this altercation, his glasses, phone, and shoes were all taken from his person. Now, there may be
modified the taking of glasses and the shoes.
As to the phone, Judge?
As to the phone, he never changed his position on that, but as to the glasses and the shoes, he modified that they were taken. They came off, during this fight, or beat down, whatever you want to call it, because it was 3 against 1. But the issue, as I see it, is the issue of the phone. And the issue to permanently deprive.
And Judge, I can speak to that. So this altercation started over money. The defendant, Mr. Dickerson, was asking for his money, $20, I believe it was, and that was not provided. And immediately following that, this physical altercation ensues, at which point the cell phone is taken from, in some way, taken from the victim in this case, and then after the fact, an Instagram message is sent to the victim indicating that they do in fact have that. So it didn't fall in a pocket and left on the sidewalk. This was taken by somebody during this altercation, which again, the altercation itself starts over money. So the people would move to bind over on those grounds.
Okay, where are you getting the permanently deprive if they're saying, come get your phone?
And Judge, the intent to permanently deprive would be present at the time it was taken, not necessarily when they're trying to return it after the fact. Because once again, people believe there is enough to satisfy probable cause standard that this is taken from it after the altercation regarding the money begins. And then whether or not they change their mind after the fact doesn't matter as to what their mindset was during this altercation.
Anything else?
No, they for the people, Judge.
Argument. Let's start in the roll. I gotta start with Mr. Johnson first. Start keep it in order.
I am going to object to the bind over and to the amended charge of unarmed robbery. Your Honor, this court has heard testimony from Mr. Henderson. There's a lot of things that Mr. Henderson testified to initially and then later on changed his mind and gave different testimony. Specifically, Judge, as to the issue of whether or not those items were taken from him, Mr. Henderson says that during an alleged fight that was going on, his glasses somehow came off and that his shoes somehow came off, but then he never went back to the same area to try and see if those items were still there. He never, there was no testimony that these items were taken from him. Yes, they came off during a fight, but there was no testimony that these items were taken from him. As to the cell phone, Your Honor, I believe that when he was being cross-examined again on the possibility of his phone being out of his pocket, and that it could have been dropped as a result. After he took off running, Judge, it is possible that this phone was taken to be returned to him, but there was no intent to deprive.
There's nothing on the record that shows that.
Well,
there's nothing on this record that shows they picked up this phone.
There isn't.
No, so that you gotta argue based on the fact, not on what on make believe.
And Judge, based on his own testimony, I don't think that his testimony shows that there were any items that were taken with the intent to deprive him from it. And so, Judge, I would argue against this bind over and object to the amendment of the unarmed robbery as well, and I would ask the court to dismiss.
I'll join in co-counsel's argument and add that I'll try to confine my argument mainly to the phone, which apparently may be an issue. And that is, the witness from Mr. Henderson obviously has some sort of a credibility problem when it comes to testifying and changing his mind or not being clear on things. We know that he admitted that he had been consuming marijuana and was drunk while all of this was going on. He did testify at one point that somebody took this phone out of his pocket, doesn't know who did it, and then at some point, I believe he's not even clear whether or not somebody actually took that phone out. Be that as it may, one way or the other, he provides to the prosecution an Instagram message that shows that the person that he knows is my client, Mr. Dickerson, is asking whose phone is this or who is this, and come get your phone. I'm not going to try to kill anybody over $20. Come get your phone. Which would suggest that there was no intent to permanently deprive. As for the fighting, we know, according to the witness, that the fight primarily was between Mr. Dickerson and Mr. Henderson. And at some point in time, Mr. Henderson says he saw a pole on the ground. He did not see anybody beating him with a pole, but he felt something that he believed was some sort of hard object. I think at that point in time, this witness is just guessing. It could have been an elbow or a fist or a foot. Therefore, I'll only argue that I don't think that in terms of a probable cause standard that they have met their burden at this stage.
Your Honor, on behalf of Mr. Brown, I echo my co-counsel's arguments, and we also object to the bind over. Judge, I think both my co-counsels have hit the nail on the head with regards to the complainant's consistency issues and also his credibility issues. But frankly, I don't believe this is at all a robbery or a larceny. And the reasons are because there's not evidence that Mr. Brown took property from anyone intending to permanently deprive him. There was the first testimony that the complainant gave was that he lost his phone and shoes. Of course, losing your phone and shoes does not mean it was stolen or taken by someone else with the intent that he would never get it back. He also testified he didn't know who took the phone. He also said he was highly intoxicated. He doesn't know at what point the phone was taken, and he never went back to see where the phone was at or to go and get the phone back. I think the text message that was introduced clearly shows there was no intent to permanently deprive anyone of a phone. This was at most a fight between individuals, not a robbery. And that's evidenced by the fact there was no testimony about statements made, especially not made by my client, Mr. Brown. In fact, there was very limited testimony about my client, Mr. Brown, and what, if any, his involvement was. Admittedly, I think the only testimony about Mr. Brown was that he was somehow involved in the fight, but I don't believe the complainant really testified about what his involvement was at all. So I think with regards to Mr. Brown in particular, there is not enough evidence to bind over on any of these charges, especially considering the significant credibility issues of the witness who was so drunk he doesn't remember how much he had to drink or doesn't remember several important parts of this incident. So we would ask the court to dismiss all the charges against Mr. Brown at this point.
Yes, Judge. So first and foremost, this would be a matter of aiding and abetting as to the other co-defendants who were involved in this. I believe it's been described as a beatdown at one point of Mr. Henderson. So whether or not they were actually the ones who took that item from him, they were certainly aiding and abetting during this altercation where they are all beating Mr. Henderson. Now, in addition to that, that message that was sent to Mr. Henderson also indicated that come get your mom's phone, if I'm not mistaken. They didn't say come get your phone, which could indicate that, indicates that they believe this was not his property, it was somebody else's property. They had deprived him of. Finally, as to the armed robbery,
Testified it was his mother's phone. That's one of the first things he said, it was his mother's phone.
correct, and the message shows that the defendant in this case who sent that message was aware that it was his mother's phone, at least at that point. And finally, Judge, the victim in this case has also testified to seeing other social media posts claiming the defendant set him up.
Your Honor, I'm gonna object. There was nothing in
It
front of
was.
this judge
He did.
in regards to the content of.
He didn't get into specifics and no one asked, but he did say that there was other social media, whatever you call them, messages put out, which basically threatened or was bragging and whatever. No one got into that, which is kind of surprising, but he did mention it. So the argument's good. You can finish.
And Judge, I would like to reiterate before renewing my motion to bind over on counts 1, 2, and 3, this argument starts over money, and they are trying to take money from Mr. Henderson, testify he had nothing in his wallet. He did, however, have a phone on his person, which was taken, and then the message came through that it was, the defendants were aware that this was his mother's phone and not his own. And we can't mind read, Judge, we can't know their intent at the time, why they sent that message or why they did what they did. But for probable cause standard, Judge, people would suggest that they intended to deprive his property from him, not necessarily his mother's property from him. So for those reasons, Judge, people would do our motion to bind over in counts 1, 2, and 3.
I don't know if I quite understand that that's part of the argument, because this property was his mother's property. It's the same thing. He possessed it, he had the right to possess it. Okay, but anyway, the court hasn't heard stuff on the argument time to follow. Or heard from Mr. Marshall Henderson on June 25th, 2023. He got together with 3 of his now ex-friends, or people he went to high school with who he thought were friends. They went to a bar. He evidently had a lot to drink, smoked marijuana. He testified that he was drunk. He identified all 3, Mr. Jackson, Mr. Dickerson, Mr. Brown. They hung out at the bar, basically closed it down, and then they left there together. Started dropping folks off. They went to 6719 Auburn in the city of Detroit. That while there, they were standing out on the sidewalk about 3 o'clock in the morning. Everybody got out of the vehicle. That Mr. Dickerson then asked, "Where's his 20?" And then, "Where's his money?" Either before he asked that or sometime during this period, he had a gun on him, and he took that gun out and he took it off his waistband and put it in his pocket. He then swung on Mr. Henderson, and they started fighting. And for whatever reason, Mr. Jackson and Mr. Brown decided to add to the fray. They then, all three of them, jumped on this one person, Mr. Henderson. During this process, Mr. Henderson, and as he described it, he said he lost his glasses. Not that they were taken, he lost them. During this fight, they got knocked off, they got pulled off, they got whatever. And his shoes. But he was very clear that his phone was in his pants pocket, which was zipped up. That he was cleared off. He did change, I'm gonna say he changed his testimony as much as he clarified his testimony. Because it wasn't that his testimony was different. You know, it's not that he said one thing on direct and something different, totally different on cross. I think he clarified a lot what he said on direct, on cross, which, you know, gave more or less meaning to what happened. He then said that in the processes, he got hit with what he said was what he described as a hard metal pole. He didn't see it, he only felt it. And then he got up to run, he heard shots, but he didn't know where the shots were coming from. Said he never retrieved his items, he made no attempts to retrieve. He never went back, and that appears to have been an issue for argument. Who would go back? It wasn't his house where this happened, it wasn't his neighborhood. It was one of the other defendants. So why would he go back over there and risk taking another beat down by 3 people? You know, that absolutely makes no sense to me. Now, the issue on the, so to me, the issue at this point levels down to this phone. That this phone was taken. And Mr. Henderson, and his testimony was clear. It was taken. He didn't drop it, it was taken. Now that becomes the issue on armed robbery, whether or not it was the issue become permanently deprived. Now there was an Instagram message sent to Mr. Henderson by Mr. Dickerson, telling him to in his own unique way, to come get the phone. I don't know when that was sent. Yeah, keep the laugh to yourself. I really don't want to do that in here.
I'm sorry, I really had it, I'm sorry.
You know, but I don't know when that message was sent. That message could have been sent 10 minutes after the incident happened. Could have been sent 3 weeks after it happened. I don't know. And because I don't know, I can't say that there was not an intent to permanently deprive. I have to believe that that's going to be left up to the trial fact. You know, I think it goes towards not being permanently deprived, but that all depends on the circumstances. And I don't have that here on this record. So, and again, this is all or nothing. I'm not adding another count of unarmed robbery. I don't see that here at all. I'm gonna find over on count 1, armed robbery. Count 2, larceny from a person, which would be, well, this says shoe, cell, and phone, it's the phone only. As a lesser intent. And then count 3, assault with a dangerous weapon, being this court finds that those in fact occur in the city of Detroit. Probable cause exists to charge these defendants. They'll be bound over to Wayne County Circuit Court Criminal Division for arraignment on the information, which will be September 20th at 9 o'clock.
Thanks, Judge.
Anything else?
Nothing for the people.
Nothing on behalf of Mr. Jackson.
Nothing, thank you.
Nothing, Judge, thank you.
Well,